You ever read that?
Yes, yes, I
Oh,
have.
I'm sure you must.
A holistic approach to exploring all aspects of well being, where we're addressing physical, mental, emotional, and spiritual health in a comprehensive way. Now, let's get to the point with our host, Pastor Edward L. Thrasher.
Hello, everyone. I am Edward L. Thrasher of Stony Point Baptist Church, and we are so excited today to have our guest, none other than Mr. Darren Kennedy from Resolutions Law Firm. Am I right?
That's correct,
Yeah,
yes.
we're so excited to have him here with, and to our welcome here to our let's get to the point. And while we're on that subject, let's get to the point. And
Sounds
some of
good.
the things you want to just tell us a little about yourself right now.
I'd be happy to. I grew up here in Hamilton County and went to local Hamilton County schools. My father was an educator and wanted to make sure that I got educated, and so I went pretty far in school, as you can guess by the law degree that I have. But um, I've been practicing law now for probably close to 20 years. And just in the last few years, estate planning has come to be one of the areas that's near and dear to my heart because having practiced in the probate area for years and seeing a lot of the struggles and trials that people go through when they lose loved ones and there's not a plan in place, including my own father when he passed away a few years ago.
Mm.
And so now I've come to recognize, it was unfortunate because I did have a plan for him, but it hadn't been updated in years, and I was busy, and he'd ask me every now and then, will you come back and let's talk and change some things, and just never got around to it. And then the unexpected happens, and we weren't prepared.
Wow.
Thankfully, having, the knowledge that I had, we were able to work through the process, but it made me realize, what about people who don't know the law and don't understand the process that you have to go through when a loved one passes away, and they have assets and a legacy to pass on to their kids, but they don't know how to go about that process. We recently rebranded and became known as Resolutions Law Firm just in the last year, and we've relocated not far from here. Actually, we're on 153 in the Hickson area, and moved into a new office there, and we're just excited and happy to be helping people prepare for the unexpected so that they're ready when things happen that they didn't plan for.
Well, again, I should say, Mr. Kennedy, we're so glad to have you here at Let's Get to the Point podcast. But I want to ask a few questions. How important it is, how important it is to have an estate plan?
Well, in my opinion, it's extremely important. When you don't have an estate plan, the state law determines what happens. And so if you want to have any say at all in what happens to your possessions when you're gone and the financial legacy that you want to leave to your family or friends or to your church or any charitable organization, if you don't plan for that, then the state has a plan that doesn't take all those other things into consideration. And so it gives you what we call the testator, the person who's setting up the estate plan, the opportunity to make decisions for yourself that you wouldn't be able to make if you didn't put them in writing before you pass away or before you become incapacitated.
Right.
So,
You said something to my ears. I caught my ears as a pastor. How often does parishioners leave something in their estate for the church? Is that common?
it is. As a matter of fact, very frequently we see lots of charitable donations made to organizations, including churches, that have been a blessing to the person who's setting up their estate plan. And so they'll put something in there. Sometimes it's a percentage of their estate. Sometimes it's a specific amount. Sometimes it's property. I handled an estate recently where the lady passed away and she left her entire estate to her church.
Wow.
It included a home in excess of $200,000 and accounts that totaled in excess of $100,000. I don't remember the exact amount, but it's close to $500,000 that she left to her local church.
I bet that pastor quite impressed and quite happy. I'm
Yes,
sure.
he was
I'm
very
sure he's
thrilled with
still-
that.
I'm sure he's still smiling. But listen, what's the difference between a will? I'm sure some of our listeners and our audience are wondering, what's the difference between a will? Because we always run to a will versus a estate plan. What's the difference? Or if there is a difference?
Well, a will is just one aspect or part of an estate plan. What happens a lot of times is people will contact our office and they've read something online, or a family member or a friend has said, hey, you need to get a will, or you need to get a trust, or you need to get a power of attorney. And so they'll call us and say, I need to get a will, can I schedule an appointment? And I say, sure, but that appointment's going to be to talk about what your needs are, so that then we can determine what documents for your estate plan are right for what you want to happen when you can't handle your own affairs or when you pass away. And I think that's the most important part. There is a difference, between the different documents that make up an estate plan, and they're pretty numerous, actually. The will is just one part of that, and we can talk more about all the different documents that typically come in an estate plan. But a will is usually, it's called, the legal term is a testamentary instrument. And as a pastor, you're probably familiar. You
right.
recognize the Old Testament and the New Testament.
Right.
And you recognize that, about the death of Christ on the cross. Well, in Hebrews, Paul talks about a testament and how that the testament is of no value until the testator dies.
Right.
And really, it's a biblical principle that the system of estate planning is based upon. So what happens is when you prepare a will, it's really your promise to your heirs of what you want to do for them when you're gone. We do for our families while we're here, but it doesn't have to stop, just like what happened in biblical times. The gifts don't stop just because someone dies. They actually sometimes get greater.
Right.
Not only do you leave the assets of your estate, but you leave a legacy, who you were as a person, what you did for your family, your character, the traits that you passed on to your children. And we try and include that in an estate plan too. It's not just about documents regarding wealth and assets. We like to give people the opportunity, if they choose to share with us stories that they'd like to pass on. We can record those. And I know when years ago we did video recordings of my mom, who was a church organist for probably 50 years. She had a stroke now. She doesn't really play much anymore. She's still with us. But while she was able to, we made a video of her playing her favorite hymns on the organ. We had my dad tell, he was an educator, but he was also a licensed minister, and he was a big storyteller. So we had him tell some of his famous stories that he'd shared with us over the years, so that we could keep those and treasure those, so that even after he's gone, we can get together as a family and listen to those. So it's not just about what you own, it's about who you are that you can pass on.
Wow. I'm sure in your line of work, I'm sure you have experienced this before when you already indicate to us that it's important to have a estate plan. But when people don't, or families don't have a estate plan, I'm sure families can come into a squabble. Have you got any stories on that?
How much time do we have? When I was in law school, one of my professors said that death plus money plus people equals litigation. And I have found that in the practice of probate law to be true. A lot of people come to me, and when they're setting up their estate plan, they say, oh, my kids get along great. And that's fantastic, but you're still here. And unfortunately, what happens a lot of times is we find out what's more important, relationships or things, when people pass away. And there are many stories. I handled an estate years ago, and it was really a sad situation. There wasn't a whole lot in the estate. The whole estate probably wasn't valued at $100,000. And that included the real estate that was involved. The mother was on her deathbed. She was dying of terminal cancer. And the daughter contacted me and said, Mom needs to get a will in place. And I actually went to the hospital just a week or so before she passed away. And as an attorney, we have to make sure that, the testator, the person leaving the will, is competent to do so.
Right.
And so I had to make arrangements with the hospital to make sure I knew when the pain meds were going to be given and when they were going to be wearing off, so I could get there at the right time so I could talk to her and make sure that she understood what she was doing and so forth. So we went through that whole process. We did the will. A week later, Mom passes away, and it was an immediate fight from the beginning. And it got so bad, the spouse of the executor of the will, his brother-in-law actually threatened physical violence to him at the property. There was a slashing of tires in the parking lot, and when we went to court, I had one of the heirs actually approach me in the hallway to try and intimidate me so I wouldn't present the case that needed to be presented. And of course, I advised the judge about what was going on, and he actually called extra deputies into the courtroom to maintain order for this probate matter. So absolutely, that's an extreme case. That doesn't always happen. But yes, most cases are disputed between family members, and we handle at our office will contests, which is, sometimes people aren't honest. They'll take Mom and when she's no longer competent, or Dad when he's got Alzheimer's, and have them sign papers, leaving everything to them.
People don't do that, do they?
Unfortunately, they do.
Wow.
Yeah, so I could tell you a lot of stories about that, but that's just one illustration of how bad it gets when people die. And even when there's not much to fight over, they'll fight over it just because they'd rather have possessions and relationships, and that's sad.
I know that has happened in a lot of cases as a pastor, because I've seen some of these cases when family members have passed on, or even before they pass, they already taking stuff.
Oh, yes.
Yeah, they getting stuff out the house or trying to liquidate stuff even before the person has passed on. So I'm sure you've seen a lot of that as well. So it's very, very wise, I believe you're sharing with us, the information that you're sharing is to have a estate plan. And even with an estate plan, can you argue over it, or is it airtight? I mean,
Yes. So I spoke a minute ago about formalities and making sure, number one, that the person that's having the will or the estate documents, estate plan prepared is competent. There's two ways that an estate plan can be challenged. Well, technically three ways if you have both of them combined. But one of those ways is to challenge the competency of the person who signed the documents at the time they signed them, whether or not they really understood what they were doing. Another way is if it can be proven that perhaps Mom's been living with one of the children for an extended period of time, and that person was acting as the caretaker, but at the same time the caretaker was influencing Mom to do what she or her husband or spouse wanted to happen with the estate plan, and coerced or put Mom under duress, and got her to sign documents that she really wouldn't have done if it hadn't been for the initiation and instigation and coercion of one of her children. So those are two ways in which an estate plan can be overturned. But I think it's important to note that if we do it properly, if you get someone who's experienced in this area of the law, that knows what to watch out for, that knows how to handle it. For example, sometimes when we have a situation where a parent is living with a child and the child calls and makes the appointment to schedule the estate plan, and then comes and wants to sit in the room with Mom while the estate plan is being discussed, one of the practices that I have is I'll actually have that child sit out in the lobby, and I'll talk to Mom by myself first in a room without anyone else present. So then if it's ever questioned in court, I can testify before the judge that I talked to Mom, there was no one else present in the room. Mom did want to make these choices. I asked her if anybody had coerced her or what have you, and so that way I'm prepared to make sure that the documents do stay intact and can't be overturned in a court of law.
Well, it's something else that came across my mind as I did my little background study about estate planning. And one of them was, what about blended family? How does the estate planning helps a blended family?
It is extremely important in a blended family. More important so than a family that's not blended, a family that have maybe a husband and wife have been together for 50 years and all the kids they have are kids together. Because even if you don't have a plan, it usually is going to go to your children anyway, and if that's what your wishes are. But when you have a blended family, there are real risks of family legacies going to a family that is not even related to the people who actually acquired that property to start with. And I'll give you a simple illustration we had recently. A gentleman contacted our office because his father had owned a family farm that had been in their family for generations. And what had happened was the father said, and he didn't consult with an attorney, unfortunately, and he decided, well, I'm going to preserve the family farm because I'm about to get remarried. My wife passed away, and I'm about to get remarried, and my new wife has children of her own. I want to make sure this farm stays in the family. So what he did was, before he got remarried, he transferred the family farm to his daughter. Well, thinking that'll take care of it because it's going to stay in the family. Now I don't own it anymore. So then he went to an attorney and created an estate plan and left what he had left, which was just, fewer assets, to his new wife. And of course they got married. Well, unfortunately, the daughter, who was unmarried and had no children, passed away before the father.
Oh, wow.
She had no will, no trust, no estate plan. And the father was ill at the time she passed away, and so he was not in any condition to go and change the estate plan that he had put in place. And when someone dies without a will or without a trust, well, it goes first to your spouse and your children, but if you don't have those, it goes to your parents. Well, her only surviving parent at the time was the father, who was also ill, who left everything to the new wife. And the family farm where the son was living, that had been in the family for generations, ended up belonging to the stepmother, who ended up selling it off. And the family lost their heirloom. So is it important to have a plan? Absolutely, and to make sure that you consult with an attorney with experience in that area so that you don't try and make that plan yourself by just transferring property thinking you've resolved the problem, because it could end up that you end up losing everything, and it was really a sad situation. I had to tell him there was really nothing that we could do. The only thing that he could do in that situation was maintain possession, and if the stepmom hadn't come and gotten the property and sold it off, he could have stayed there for 20 years. And there is a common law rule of adverse possession where he could have taken some ownership, but you have to stay there for 20 years with no interruption of that possession for that to be valid. And so, unfortunately, that didn't end up happening in his case.
Wow. Is it planning a estate plan, is it costly?
It is, yes. It's not a cheap process, and I'll give you a reason why.
So pay me now, pay me later. That's the
Yes, that's exactly right. At our firm, we offered two different, well, more than two plans, but two main plans that people typically go with. If you don't have a taxable estate plan, which is in the millions of dollars, then there's two main plans that most people go with. It's either a will-based plan or a trust-based plan. And the difference between the two is, with a will-based plan, 9 times out of 10, you're going to end up having to go through the probate process. And what that looks like, we can talk more about what that looks like, but basically that means you're going to have a supervised, court-supervised administration of your estate. And that's not a bad thing. Tennessee is one of the better states to have to probate in, but there is a cost to that. And so, an average cost for an average size estate here in Hamilton County probably runs anywhere from $5,000 up to $8,000, could be even more than that depending on the size of the estate. the number of the beneficiaries, the number of the assets, type of assets, and so forth. But there is a way by doing a trust-based estate plan to avoid probate altogether. And so you pay a little bit more on the front end for the trust-based plan, but you avoid that $5,000 to $8,000 cost potentially post-death when you're administering the estate. And another benefit to that trust plan, and we can talk some about that as well, is that when you have to probate an estate, there's a will that says, I name my son or my daughter as executor of my estate when I pass away. And people think, well, if I'm the named executor, as soon as they die, I can take control and start doing things. Well, unfortunately, you may be chosen and designated as that person, but until you actually go to court, open the estate, and receive letters testamentary, which is basically a court order that says you are now the executor of the estate and have authority to act, you don't have the authority to do a whole lot. And so we run into problems with that because right now it takes approximately 30 days to get an appointment to get the estate open. So what happens during that 30-day time period while your family member is deceased, but there's not a whole lot you can do to further the administration of their estate until you actually receive the appointment in those the court order that are those letters testamentary or of administration if there is no will. So that's one aspect with the trust too, is that the successor trustee is named in there, but immediately upon death, they are now the trustee, and they can act immediately. A trust is somewhat like an entity, like a corporation or an LLC in certain aspects, meaning that it can actually hold title to assets. So when you do a trust-based plan, instead of me owning my property would be transferred into that trust. I'm still in control of it because I'm the trustee, just like if I was the president of the company or so forth. I can sign documents, I can transfer deeds and titles, I can borrow money in the name of the trust, usually with a personal guarantee. So I can basically do anything I can do as a person, but the benefit is now all that property is in the name of the trust. And so immediately upon my death, my successor trustee can step up and immediately start distributing those assets, paying any debts that are outstanding, signing deeds, taking care of business without that delay, and saving that cost of probate administration. And the other benefit too is there's no time constraints with that. When you probate an estate in Tennessee, there's limitations just over a year in which you have to complete that probate. There are extensions that you can receive, but within the first 60 days, there's a number of responsibilities the executor has to take care of very quickly. You have to file an inventory if it's not waived in the will. You have to send out notice to the beneficiaries. You have to send a request for a release from TennCare to see if there's any lien out there against the estate that might be due and payable. And all those things have to be done very quickly, or it could be grounds for your removal from your position as an executor, and the court appoints someone else to take over that. So those are some of the differences and benefits between a trust-based estate and a will-based estate. And to be honest with you, what you pay to probate the estate is the savings from that is more than you're going to pay for that trust-based plan in most cases.
Wow, this is a wealth of knowledge. I'm telling you, for those who are watching, our audience are watching, I'm sure they're taking all of this in. It's a lot to take in, but yet it's still a wealth of knowledge, and it putting out our wheels of thinking on as well. You went back to the executive of the will. I was listening. Just because you are the executive, that don't mean you can do what you, as you stated, that don't mean you can do what you want to until that person is gone on, right?
Correct.
But what if the person that made you the executive not in their right mind, and they needed to liquidate some of their, say, house or whatever?
Okay.
How do you handle that, or if you can handle that? Can the executive make that call or do it?
That's a great question. So that brings up a time to talk about one of the other documents that typically is involved in an estate plan, which is called a durable power of attorney or a durable general power of attorney. When someone is living, their will really has no effect. It only becomes valid upon their death. Up to that point, it's revocable. It can be changed. The executor has no authority to act on their behalf until they actually pass away, and the estate is open with the court, and they receive that court order stating that they are now in authority to act as the executor of that estate. So one of the other documents is this durable general power of attorney that you can designate someone. It can be a family member, it can be a trusted advisor like an attorney or a CPA or a financial advisor. It could be a pastor, for example. Someone that you trust, and I see that quite frequently actually, pastors being named executors and powers of attorney. But that is a document that's valid while you're living. And it gives the person designated as your agent the right to act on your behalf, and the durable portion of that identifying name of the document means that it remains effective even in the event of your incapacity. So, for example, you and I are talking here today, and I prepare a durable power of attorney for you, and you appoint an agent, then later on you're diagnosed with dementia or Alzheimer's or something like that. The person that you've designated as that agent can then act on your behalf, and they can do anything you could have done for yourself. The law does point out, though, that it is a fiduciary responsibility, and what that means is it's a duty owed to the person who gave you that power, so you can't go out and write yourself a check out of their account. You can reimburse yourself for expenses incurred for the benefit of the principal, we call them, the person who granted that power. But it's a great way to provide for yourself in the event of your incapacity. And that even is in the case of maybe it's not Alzheimer's or dementia. Maybe you're just in a car accident and you're unconscious. You know, who's going to take care of your business? Who's going to make your mortgage payment? Who's going to pay the bills that come through? Who's going to make decisions for you while you're in the hospital and can't do that for yourself? So there are two types of powers of attorney. There's one for personal affairs where you can handle the business matters, and there's also one for health care where you can make those decisions that the principal couldn't do for themselves because of the present condition that they're in.
Wow.
There's an illustration, if you have a second, I'll share
ahead.
with you,
Yeah, sure.
just to point out one more point about that. We talked about an agent to act on your behalf. I highly recommend that you name a successor, and preferably even two successors on that particular document. And the reason for that is because, let's say that your agent that you've appointed is in the car wreck with you, and they can't act for you. Then what? You've only got one person. A few years ago, I had a gentleman whose wife was in the early stages of Alzheimer's, but she still was competent enough to sign the document. And so he asked me to prepare a durable power of attorney, and I said, talked to them. I said, well, who do you want to act as your agent? She said, well, my husband. And I said, well, would you like to name any successors, your kids or anyone else? No, just my husband. Well, unfortunately, she got further into her Alzheimer's and became incapacitated, but he predeceased her. And then what happened was, for the kids to take care of her affairs for her, they had to go to court and file a petition for what's called a conservatorship. And a conservatorship is basically a court-appointed person to be the power of attorney for someone who isn't able to handle their own affairs. The only difference is what you paid for your estate plan that's going to include that, that's going to include the trust, that's going to avoid probate. You're going to spend another $3,000, $5,000 potentially to get that conservatorship set up. You're going to have to go file a motion periodically with the court, because it's court supervised, to get those decisions approved before you can spend certain amounts of money on behalf or for the benefit of your parent. You're going to have to get approval if you need to sell some of their assets to provide for their needs. And you need an attorney to file that motion, because most people don't know how to prepare those documents and appear in court. So you have those ongoing costs on an annual basis. And then usually there's some sort of an annual report that has to be filed with the court, maybe even an accounting in some circumstances. So having one simple document can help you avoid a lot of that cost, a lot of the stress, and a lot of the oversight of someone else who doesn't even know your parents, maybe making a decision, having to approve decisions that you feel are in the best interest of your parents, but maybe the court doesn't agree with you.
Now, is estate planning only has something to do with property, Is it more than just property? What about 401ks and things of that nature?
It includes any asset that the person who's preparing or having the estate plan prepared for them may own. It can be retirement accounts, bank accounts, vehicles, household furnishings, jewelry, artwork, real estate, just anything pretty much that you own and have in your possession. It can even be intellectual property if you have trademarks or patents that you have come up with and registered with the government. If you have an ongoing business, you can pass that along to your kids through your estate plan and set up people to do that. We recently in court, there was a local gentleman who passed away, had a business, and they had to put someone in place to run that business until they could get it sold because no one in the family knew how to run it because it was his specific business. But that's another asset that's included in his estate typically.
Wow. This is a lot of information that you're sharing with us today, Mr. Kenny. We thank you so much for coming. Is any questions or there's frequent questions that we may have in our mind that we hadn't asked? When I go to a doctor, you ask this question, but until you ask the question, they don't seem to want to tell you anything. So is anything I haven't asked? And a lot of this has to do with just my research. There was one other question. I think I did some research this week. I'm not sure it was America. I'm not sure it was ethnic groups, but I understand like 67% of people, Americans, is that about right, don't have an estate plan?
That I have not researched that specific statistic, but I would tell you from personal experience by the volume of estate plans that we're doing at our office through the marketing that we've been putting out, because our goal is to see everybody in Hamilton County have an estate plan because I think it's that important. And so I would say that whether that's accurate or not, I don't know for certain, but I would say there's a high percentage of people that don't. And number one, it's cost prohibitive to a lot of people. And so our desire is, if people don't have the means to do that, I don't want them to stay away because they're afraid of the cost. We work with people on a payment plan if necessary so that they can get that estate plan in place. One of the factors that I oftentimes share with my clients when they come in for their consultation, because I'll ask them for some stuff, and a lot of people are, private with their matters. They don't want to disclose everything to you. Always, and so I'll ask them, well, where do you bank? Will you provide me with some account numbers and things? And of course, with all the scams out there, that's concerning to people. And they ask, well, why do you need that? And I said, well, one good reason. If you go online and you Google Tennessee unclaimed funds and you look and you read what's there, you will find that every year there are millions of dollars of unclaimed funds that are sent to the state of Tennessee because people have passed away. They didn't have an estate plan that included a list of assets so that when they pass, their children may not know where they bank. And how do you find someone's bank account if they don't tell you?
I did that. I was hoping, I was praying that I would find my name on that list with a lot of zeros. But of course, that wasn't the case.
That's true maybe for you, but I tell you,
there's some people that,
there are people there. I have an estate right now where we were able to locate, and the money has been received from the state of Tennessee back into the estate now that I opened for a family that was in the amount of $97,000.
Wow.
That would have been lost because eventually that money does what we call escheat to the state. It's E-S-C-H-E-A-T. And that basically means that at some point, if it remains unclaimed, there's a time period within which that money will belong to the state of Tennessee. And we hope they put it to good use if that's the case, but wouldn't you rather see it to go to the heirs of the family members who've lost it?
Yeah.
And so, that's why it's important that we have these plans in place and we have a list of the assets because, if your kids have moved out and they're older, most of the time when people pass away, they're older and their kids are grown, have their own home. They haven't been with mom and dad in years. They don't know where the will's located necessarily. Mom and dad may have changed their bank account, or maybe they years ago decided to put a safe somewhere and hiding in a closet or up in the attic, and you don't know it's there. So if we compile a list of assets for you and put that with your estate plan,
And you do all this.
we do all of that. It's all included.
Give us that website again for those in our audience today, as well as our family on social media.
Sure.
So to find that claim. It's
I don't know the specific website. It's Tennessee.gov, but there's something that goes beyond that. But if you just Google TN unclaimed funds,
unclaimed fund. Okay.
yes,
Okay.
and you can go there and put your name in, and maybe you'll get lucky. It might be
try
win
that
the
again.
lottery.
Yeah, I might need to do that again. It's been several years since I've done that.
Yeah.
So I might need to go. You already checked. Checking on my money. Hey, my sister checking on my money. Oh wow! I'm checking on yours next time. But what else you can tell us about the estate plan? I mean, that would be very informational to us. As
Sure.
I'm sure there's a lot of wealth there. I mean,
Well, let me tell you just a few of the other documents that we have in addition.
Okay.
We've talked a little bit about the will. That's the instrument where they make choices about what you want to happen. The trust document, it's nice because you can use it while you're living. You can have your bank accounts open in the name of the trust, and so you can use that while you're living. You can title your assets in the name of the trust and use that while you're living. But then when you're gone, you have that immediate right to possession for your successors, which we've talked about. We have the general durable power of attorney, which we've discussed a little bit. We have the healthcare power of attorney. And that's an important document too, because one of the things that people struggle with, and I know that I had to do this, my mom and I had to do this when my grandmother had a stroke and was in the hospital unconscious before she passed away. There's tough decisions you have to make. Are we going to let them stay on life support indefinitely? Is there some point when we're going to take them off of that and put them in the Lord's hands and let what happens happen? And so that healthcare power of attorney, several years ago, I think it was in 2017, the law changed in Tennessee, and now they incorporate what's called an advanced directive in with the appointment of a power of attorney as your agent to make those healthcare decisions. And the benefit of that is it asks you some questions about certain health conditions, which typically we would consider end-of-life conditions. Some examples would be, in a permanently unconscious state without any probability of ever coming out of that unconsciousness. Advanced stages of Alzheimer's where you don't recognize your loved ones, you can't carry on a conversation because you just don't remember anything. Or maybe you're in a vegetative state where your existence is in a bed where you can't do anything for yourself. And then one of the other ones would be something like a terminal illness, like in stages of cancer, or what my dad passed away with, which was renal failure. He was on dialysis for a number of years. And it allows you to say, okay, if I'm in that condition, do I want to be kept alive indefinitely when I have no quality of life?
right.
And so it allows you to make those choices for yourself while you're still able. And in my opinion, and in my own personal experience, it was a blessing because I didn't want to be the one to say, my grandmother, it's time for her to go, But when she has a document where she says, if I'm in this situation, let me go. Then we can know that even though it's still a hard decision and a choice to make, we can make that decision knowing that it was her wishes and we're doing what she wanted rather than making that choice for ourselves. So that's an additional document. One of the other ones that we typically include is what's called a HIPAA waiver. You may have heard the term before. It's basically just giving people the right to access medical records. And you say, well, what's important about that? Well, what if your loved one passes away due to an auto accident that wasn't their fault? You may have thousands and thousands of dollars of medical bills, and you need to pursue collection of those, against the person who was at fault or against, if they're insured. And so that would give you the right and get access to those medical records so that you could use those to show not only the damages that were sustained, but the bills that were accumulated, and so forth, so you can pursue collection and so that your estate isn't wiped out. I mean, someone's estate could be completely wiped out by medical bills that was no fault of their own at the end of their life. So that's an important document. In addition to that, we usually include what's called final disposition instructions. People have preferences. Do I want to be buried? Do I want to be cremated? If I want to be buried, do I want to be buried in a certain cemetery? Do I have relatives who are located in another state? I know in our family, my mom's whole side of the family is buried at a cemetery in Florida. And so, maybe your kids know about it, maybe they don't. Maybe you don't have any kids, and maybe you've appointed a friend who's going to be that executor of a will. They may not understand the significance and importance of having you buried with the rest of your family in Florida. And so you can fill out that form and give some directions and instructions as to what you want to happen with your remains when you're gone. Okay. Gives you opportunity for organ donation and things of that nature too, if that's important to you. So that's something else that we always try to include as well. So that gives you a general idea and overview of what a typical estate plan would include. I don't know if that answers the question, but
is you too young or too old to have an estate plan?
That is a great question on a topic we haven't covered at all tonight. And one other aspect is the importance. It's never too late, but it's never too early to start planning. I had someone call me just this last week. They're a young couple in their 20s, and they just had their first child. And I was really impressed because their first thought was, what's going to happen to my baby if I die unexpectedly? And part of an estate plan is designating guardians, caretakers that can take over and assume raising your children when you can't do it for yourself. And so that's another aspect of it. Whether you have a will or a trust, you can designate and appoint guardians. Even now today, like let's say you're in a car wreck and your child is with a sitter and it's a minor child. What if that sitter doesn't have authority if your child gets hurt to authorize medical attention? We can authorize that nanny, that child caretaker to have a limited power of attorney for health care for our children, to take them to the hospital. And that would include who their doctor is, what our insurance is, have the information for our insurance provider with the policy number and so forth, so that your babysitter can take their kids to the hospital and get the medical attention that they need and have all the information ready to get that treatment ASAP so that we don't get stuck in that position. What if I die in a car crash and I didn't designate someone? If there's nobody with authority to act on behalf of your children, they could end up in Child Protective Services or in a foster home until somebody comes forward and proves that they're related and that they have some right to that child. And so there's a lot of aspects that we don't think about as young people that could be dealt with in an estate plan and taken care of, so that no matter what happens and when it happens, whether expected or unexpected, we're prepared.
All right. At this time, Mr. Kennedy, we want to take some questions from the audience, and
Sure.
those who might be online as well might have a question. Who would like to be the first one? No, gotta come to the mic, please. The mic, so we can hear you.
Is there a difference between a power of attorney and a dual power of attorney?
Yes, that's a great question. 100% difference. There are specific powers of attorney. For example, you may authorize if a husband and wife are in the process of selling a home and maybe one of them travels for work and has to be out of town on the day of closing. Typically, a title company will prepare what's called a specific or limited power of attorney that's only good for that one transaction. And so the big difference is with a durable general power of attorney, it grants basically carte blanche authority to do whatever that person could do for themselves, and it's a perpetual power of attorney, meaning that it's good unless and until it's revoked by the person who granted that power. So, excellent question. A regular power of attorney is only limited to specific things, and once that specific authority is completed, then that power of attorney is terminated by operation of law, whereas a durable power of attorney is ongoing and perpetual unless it's revoked, and can be used for any number of things rather than just one specific purpose.
Oh, I understand now, because I was hospitalized in two different hospitals, and they asked if I had a power of attorney. And of course, we had to give them the power of attorney. We had to bring the documentation in and prove that we did have one in the event that I got to where I couldn't do anything for myself, then they could come in. Of course, our daughter is a nurse, so that wouldn't have been a problem. But I didn't know there was a difference between the dual power of attorney, who has more authority.
Correct.
Oh, okay. Thank
Yes,
you.
ma'am. Correct. Good question.
Put it right here. Right here. Will, where you get? Anyone else want to have?
I remember earlier you said that the durable power of attorney is good for while the person is still alive.
Correct.
So, and I didn't catch what you meant. What you said was the next step.
So a durable power of attorney is the mechanism that grants authority to act on your behalf while you're living,
Yes.
and then your will or your trust will designate a successor that takes over when you pass away. And as we discussed earlier, the executor doesn't really have that authority until they're actually appointed by the court, which there can be a significant delay between when the person passes and when they get an appointment to open the estate and actually get that designation by letters testamentary. But with a trust, for example, you're named a successor in that, so the moment that they pass away and you have evidence of that death, you are now the trustee and can act on their behalf in that capacity.
Okay. And that's transitional from that original document. You don't have to petition for that.
No, not if it's a trust. You don't have to
Okay.
petition for that. You just have to have proof of death
Okay.
or incapacity.
And the other thing that was one of the questions is, what is probate?
Probate is the process, the court process by which your estate is what we call administered, which basically means that the documents that have been prepared, if any, are presented to the court, and as long as they meet specific formalities, and that's one thing we haven't really talked about tonight, is how do you create a will? What are the legal requirements? As long as it passes those tests and is sufficient, then the court will admit that will to probate. And then probate is the process where the named and appointed executor begins to gather the assets together. So they would go to the bank accounts of the decedent, and they would close those out and have checks issued payable to the estate, and then they would open a new account and put all those into one place. They would gather the vehicles, and if they weren't specifically gifted to someone, then they would sell those and put that money in the estate account. If they had a home, if that wasn't specifically designated to go to a beneficiary, then they would probably sell that home as well and put that money into the account. And then whoever were the what we call residuary beneficiaries, those are the people that get either all or a percentage of the entire estate, would then receive those benefits. Part of that process, of course, includes a time period for creditors to make claims, and so that's part of the probate process. And then once all the claims are paid, all the debts basically, once all the money has been distributed, then the estate is closed out, and then your authority to act on behalf of that deceased party is no longer pending.
Okay. That explains why it takes a long time to from the beginning to the end to resolve an estate?
Yes, and that's a great question because, it takes 30 days usually to get it open. Once you open it, you have to give creditors notice, and there's a 4-month window where if you give actual notice to known creditors, they have to file their claims within that time period, so you have to wait. And so it's kind of a hurry up and wait. You file paperwork, and then you wait for several months, and you file more paperwork, and you wait. But usually, a year to a year and a half is a typical time frame for a probate process to go from start to finish.
I understand. Thank you.
Yes, thank
It's
you.
a process, isn't it? See, it's a process.
It is. It
Anyone
is.
else would like?
How you doing?
Good.
Okay, so you say that, first of all, I work for the city of Chattanooga.
Okay.
So when you say something about the achievement, we also processing, getting out, all these funds together for everybody to go on and claim whatever.
Right.
Like not Georgia Power, Power Company, T-Mobile, any business that you can claim, you might not claim something too. But, my thing was, I see a lot of, people in there, cause I worked in the treasury department
Mike.
also.
Okay.
And I see where, a lot of people was arguing about estate, property and who's gonna get what. But my question is, if you have a trustee or durable and the trustees are two different, right? The durable-
Correct.
Okay. And then you have, the deceased person, and then another person on the deed. Does the durable power attorney or the trustee still have control of everything?
That's a
I'm
good
seeing that.
question.
Yeah, it is a good
And
question.
I want to make sure that I understand it. So let's talk we're talking about real estate, correct? Okay. So let's start with the real estate aspect first. In Tennessee, real estate, if a husband and wife collectively purchase property, it's held as what we call tenants by the entirety. And what that means is that both spouses own the property, but upon the death of one of them, the survivor automatically becomes the sole owner. You don't have to go to probate, you don't have to have a trustee, you don't have to have a power of attorney or anything. The survivor becomes the sole owner of that property. So now what happens when that person becomes incapacitated or passes away? Well, if they become incapacitated, hopefully there's a durable power of attorney in place, and that's the instrument that provides someone authority to transfer title on that if it becomes necessary while that person is still living, okay? When they pass away, if they have transferred that property from their personal name into themselves as trustee of their trust, and it's no longer titled in their personal name, then the trustee can transfer that property while they're living or after they're gone, either way. If they don't transfer it into the trust, then there's a couple of means how it can be conveyed. There is a way, if you don't have an estate plan, that you can potentially avoid the probate process by doing what's called an affidavit of heirship. And this may be a little bit beyond the scope of your question, but I'm just trying to give you the whole picture here. So you can have family members and a third party who is not a beneficiary of the estate sign an affidavit saying that, John Doe was the owner of this property. That was my father. He passed away. He wasn't married. He didn't have a will, and he left and I'm his heir, or his only heir, or me and my siblings. My siblings and I are the only heirs to this estate. And then you can record that document in the Register of Deeds office, and that's evidence that by state law, when he passed away, that property conveyed automatically to his heirs. So that's another process by which it can happen. So there's 3 or 4 ways a property can be transferred. I don't know if I answered all your questions, but just to recap real quickly, the first way is by power of attorney, durable power of attorney, while you're living. When you pass away, if property's held in your personal name, you can either do an affidavit of heirship if there was no will to show that the heirs are now the owners of that property, and then they as owners can transfer the property themselves. If there was a will and it leaves it specifically, then you can probate that will, and once you're named and appointed executor, then you have authority to transfer that property after the original owner passes away. Or if during their lifetime they titled in the name of a trust, and that successor trustee would have authority to transfer that property after they're gone. Does that answer your question? If not,
Do that answer my question? Do that answer my question? But what I get, yes, I think it does. It was something you said. I'll come back if I think about it, but I think it does.
okay. Well, if you think of any other questions, I'll stick around for a few minutes after if you want to ask me.
Okay, we thank God for Let's Get to the Point podcast. We certainly thank you, Mr. Kennedy, for coming in and be a part of Let's Get to the Point podcast. I wonder, is there any questions on social media before I close out? Ms. Warren?
The answer is maybe. There are statutory requirements for a document to constitute a will in Tennessee, and there's a number of different types of wills. There's a holographic will, one type, which is a document that's completely handwritten by the testator, the person who's writing the will, and they can sign it. It doesn't have to be notarized. It doesn't have to have witnesses to be valid, but you will have to have two witnesses come in and testify that that is the handwriting and the signature of the person who's now passed away. Then you have a typewritten will, and yes, a typewritten will that is notarized document can serve as a will, provided that there are two witnesses to that will, and they typically have to also sign what's called an affidavit of subscribing witnesses, or else come to court and testify that they met all the required formalities, which are they were present when the testator signed the will, and they watched that person sign the will, and then they signed the will as witnesses in that person's presence as well, and then the notary was present to notarize their signatures. And so those are some of the formality requirements. So to answer the question, it's possible, yes, that a notarized typewritten document could function as an estate plan, but I would highly recommend you get a professional opinion, because I've got one right now where the family can't figure out how to get their estate through the process, because the person named in the will wasn't done properly, but then it left it to someone, a child who was a special needs child and couldn't handle his own affairs, and it's just been tied up for a long time, and we haven't been able to get it resolved. So definitely, I have nothing against companies online that want to make money, but if you're not getting competent legal advice with the documents you're purchasing, you may be wasting your money. So if you're going to get one online, pay somebody to look at it and review it and make sure it's a valid document before you count on it and rely upon it. And with that being said, I do want to say, thank you for having me today. I love the opportunity to share with people and tell them the importance to me of an estate plan. And for those of you who are here tonight and those who are listening, we want to provide a discount because we think it's so important. One of my staff members is here with me tonight, but we're offering a discount. So if you're listening tonight or you're here present, contact the office and say you heard us on the podcast, or get one of our discount cards here, and we want to give you some incentive to go ahead and get the plan in place so that you're not one of those people who are unprepared when something unexpected happens.
Great, that's good. That's good news to hear that we get a discount.
Yes, sir. Yes,
I like
sir.
that. I like discounts. Love discounts. Thank you so much, Mr. Kennedy.
Thank you.
For coming and being a part of Let's Get to the Point. You truly got to the point in the conversation. It was really nice having you here tonight. And I believe those who listen to us by social media and those who are in the audience was very enlightened and empowered by the information. For those who may not understand, this podcast, as a church, we believe in holistic ministry. We want to not only deal with the spiritual life, the soul, we want to deal with your mind, your body. We want to deal with all part of our souls. And with this podcast, we hope to be able to do that, dealing with different subjects and topics that we may have and come once a month on the fourth Tuesday at 6:30 every month. So we thank you for coming and being a part of this. Let's get to the point. And
Thank
you
you.
certainly did that tonight. Thank you.
Thank you.